What do you got there?
All right. I think we are live here.
It's
Welcome,
called Bang. I don't know. Yeah, I'm just kind of trying to be vitamin myself a bit. So
welcome everybody to this week's edition. We are still in the green room, I guess, but we are live. Welcome everybody to this week's edition of the Expert Witness Show with Doug Miner and Stephen Palmieri, and special guest James Kelly. James comes to us from the mortgage arena of things. He is a true gangster when it comes to countering the acts of the big gangsters, which are the mortgage companies and stuff. So, James, thanks for joining us today here, man. Appreciate you coming in, and Doug, always good having you. And so, we've talked a little bit, James, about, your skill set. You kind of really have a niche where it comes to these big giant banks that securitize these mortgages and have these like missing chains of title and all this stuff that's not supposed to happen. Most of the people watching this, we do credit repair, and there is definitely kind of a middle road where if we can learn how to ask for the right things for mortgage, which we have RESPA and we have qualified written requests, we have tools at our disposal to be able to ask for documents. But if we don't really know the rules of the game, what's going on behind the scenes, we don't even necessarily know what to ask for and stuff. So, James, why don't you go ahead and just give a quick intro beyond that, kind of how did you get into what you're doing here for our audience?
well, my background, I've been a real estate investor since around 1990, and towards the I think around 1997, becoming a banker complemented my real estate investing, since I was learning, how underwriting works. And I ended up over like the following decade, probably getting credentials and probably set for about 70 certifications in both commercial and residential lending. I saw a bit of a conundrum that made me cautious, where there were so many regulations in the U.S. and various agencies basically regulating, and like Truth in Lending and RESPA. There at one point in the 90s, they had two different definitions for an application. So you're like, which do you choose? And so it kind of made me nervous. So I really focused more on my real estate investing than in the banking work, which I really liked banking. I mean, I thought it was unusually profitable when you look at an amortization schedule and you see how much money a bank makes. Over a 30-year period, you're paying them back 3 times, essentially.
Yeah.
Jump forward to around 2006, 2007. As the market started to crash, I was actually in a very good position with properties in 6 states in the Virgin Islands, over 100 lots to develop, both commercial and residential. And as we went into that period where credit froze, there was so much, I want to say excessive compliance regulations that I couldn't imagine when I get a call from, say, Wells Fargo, a bank I've never done business with. If they say they own my mortgage, I just sort of took it for granted. And as I went forward around the 2006, 2007 period, I noticed some strange activity, the way they were processing mortgages. And as 2008 hit with the crash, suddenly everything turns upside down. And even though, for example, I started to borrow some money to build out a project that I had, I believe it was 19 units. I owned it free and clear. And what ended up happening, when they looked at my assets, they wouldn't turn me down, but they would never fund it. And so at one point in 2007, one property was worth 700,000. And suddenly Wells Fargo is telling me it's worth 150. So I'm cross-referencing comps, and I'm seeing a neighbor's property sell for 650, and it's collecting $2,000 a month less in rent. And so part of that, I guess I can be very long-winded explaining the details of this, but basically the way the system started unfolding is that big banks and Wall Street had basically sort of captured us and our pension funds and a number of other investors. And as you start to unravel it, it starts taking you outside of traditional banking. And basically, I would say I've spent over a decade unraveling and following the evidence, and it takes a lot of work. So,
Or, go ahead. I'm sorry. Yeah. Go ahead.
Well, my specialty, it led me to Remick Trust. And so the reason I focus on that is that I deed over 42,000 Remick Trust. And there are reporting agencies, or I should say more like database agencies, that will claim there's less than 10,000. And so, there's a lot of, you'd almost want to call it a shadow banking, economy operating in the background. And so, getting the details and being able to prove causes of action like unjust enrichment, I believe that's, really a big part of the cornerstone of what we're dealing with. And of course, the way it relates to your work is that, if you're working with, say credit cards or car loans or medical collections, there's a good chance that person's going to be later in the mortgage. And so, bringing this all together and applying the same rules, whether it's FDCPA or the Fair Credit Reporting Act, there's many places where they relate. So what I'm hoping is that, by conversing, we can find some middle ground to streamline some of the work we're all doing.
Awesome. So let's kind of dial it back for the high level so people can kind of understand what we're talking about. And Doug, feel free to obviously chime in as well. And I'd love for us to talk about damages and stuff, at some point here, but just to help the folks understand. So basically, in very simple terms, what happens is you want to buy a home and you don't have enough cash, so you have to borrow the money. So you go to the mortgage company, and the mortgage company, they get funded by big giant institutions, warehouse lenders, people like that just give them big giant ass lines of credit. And so especially in 2008, 2009, what was happening is there would be these big giant institutions. We won't say the names, but you guys all know them. And they're like, okay, we're going to go ahead and we want the loans to look like this. And we're going to go ahead and give $500 million of warehouse credit to this mortgage company. And we want this mortgage company to sell these types of mortgages. And when they create these mortgages that look like that, then this big giant company that put their money on the line, they'll take all these mortgages, package them up, and put them in a trust and sell bonds to collect money instantly, backed by the future cash flow of the 30-year mortgage. And to sell these bonds, you have to have a bond rating. And because they were backed by mortgages, the bond rating companies gave them like AAA ratings, even though a lot of these people may have had subprime 550, 580 credit scores. But they were like, oh, well, these things are backed by mortgages, so they've got to be the highest rating out there. So then you've got all these people, you've got all these bonds being sold on the market to like the pension fund people and all that you were mentioning, and they think they're buying AAA rated instruments because that's what they were rated at, but they were backed by mortgages, but they were really the consumers were subprime consumers. And so when the subprime consumers who were not really AAA rated started to default, everything kind of fell apart. So that's like a high level. Okay, you've got these mortgage companies putting mortgages together, and then these mortgages are getting turned into bonds and into these big trusts. And then when you do that, you had mentioned a Remick trust. So for folks who aren't familiar, it's REMIC. It stands for Real Estate Mortgage Investment Conduit Trust. And that's a special type of trust under the tax code that has like limitations and restrictions and how it's supposed to be done. So kind of dial it back in. So what we have here is basically like this underworld James was saying of all these, and this isn't now in this day just restricted to mortgages. Private student loans are being securitized, credit card debt is being securitized, auto loans are being securitized. Now, securitized is basically just a term of taking a cash flowing asset and selling bonds secured by that cash flowing asset. So James, James, kind of back to where you are now that we've kind of done a very high level, I guess. So anything you need to correct me on that on the super high level? I mean, don't go into like dotting the I's and cross that T's, but is that a general description of what's happening?
Yeah, I think, for people who read more detailed articles, I believe in regards to 2008 crash, there's a lot of validity of what you're stating. I think what we really should do for a second, for clarity purposes, is to back up and remember the traditional use of banks and how they would lend money. And essentially, if Bank A took a lien on your home and gave you $100,000, what they would do is run down to the say the county register of deeds and record that in their name, due to the fact that that was now an asset of the bank, and that basically it was to the benefit of the stockholders. What ended up happening, I would say, after the 1986 Tax Reform Act, is that big banks in Wall Street, and I would say less than 100 banks for the most part, found a way to create more money. So even though in the United States we have over 5,000 banks right now, less than 100 of them decided that they could circumvent the system. And so they started using a third-party database named MERS, and they used these remit trusts, which has a tax, I would call it a tax evasion aspect. So now you've got less than 100 banks that don't pay their taxes. Even though you and I and pretty much anyone paying the mortgage is having, to pay the interest, which that is the income to the banks, this small group of banks were not paying their fair share. So then as you jump forward, you start realizing they were selling these bond certificates to our pension funds. And so essentially what they did was create a situation where they can make unjust enrichment or more money than they're entitled. So I would just, try to point at traditional bank to remit trust. We're not the only victims, the consumers. I mean, our pension funds haven't realized all their losses, most likely. So I just want to clarify, that's kind of the big break between the 2008 evidence and what we're just discussing. So do you understand how it merges together?
Sure. So, well, Dougie, I saw you were feverishly writing down some notes a little bit earlier, man. Let's get you chimed in here, man. What do you have to say about all this at this point?
Yeah, super interesting, first and foremost. Secondly, there's some parts of it where I'm sort of questioning the cross, let's say, the credit repair industry and what you're doing. So in these trusts, the cases come up on my end, right, where somebody's reported something inaccurately. And then there's a dispute over who owns the property, if the property's gone into foreclosure of some sort, something along those lines. And I'm thinking, James, is that sort of where you're seeing the crossover between what you're doing and then the credit repair industry guys?
Yeah, I think a lot of it is bringing conformity. The accounting that I see on the credit report, the accounting I see on a client's mortgage statement, they should be the same. And the same applies, even though it's difficult to get to, when you go to these statements that are issued to the bond certificate holders of the remit trust. All of these numbers should balance. And when you start reconciling that along with the county land records and the SEC records, you'll suddenly find that it's literally an Al Capone situation where there's two sets of books, and it just doesn't match up. And that's part of the critical flaw we have right now, is getting all that information and then getting the courts to hold the guilty parties accountable. And that's why I was pointing to you, when you show damages, then hopefully, and my preference is to bring, say, 3 to 10 people in, whether they're witnesses or mass joinder, to show that these parties all have similar damages, and they're all identified to the same remit trust with the same tax ID number. That's my goal, but it's a lot of work, and finding people who want to do this. They're like an attorney who wants to take on something that tedious as opposed to the one-off cases. It's very difficult, and the one-off cases are very hard to defend, especially if they can't prove damages.
And so when you see damages, so from my side of it, right, where I see it's fairly, in my mind, it's fairly simple, right? The information that hits the report on someone's credit profile is, let's say, negative or derogatory in some fashion. And in these mortgage situations, it typically, it ends up in a foreclosure being reported, or even if the foreclosure even goes through, right? So the damages, when I look at them, are direct to the socioeconomics of the individual and then how they use their credit in their life. Whereas I'm trying to figure out a way that, do you see a way of approaching the damages, or do you have any thoughts about that at this point from what you've seen in the cases?
You see, my approach, I'm a 95% prima facie evidence expert witness. I basically discreetly dig into case files. And this is really important if you really want to dig into this type of work when it comes to when it involves mortgage fraud, and especially random trust. You really have to be discreet. I've seen records changed, and you've got to remember, digital data can be changed very easily. And when I make these statements in the future, I'll be publishing it. I can prove what I'm stating. In fact, on the flyer that or the slides I sent Stephen, I have one from the largest financial database in the world, Bloomberg Terminal, where I proved that their data was being manipulated, and they ended up deleting the function. So I feel like I'm kind of going outside of the question you asked, but it ends up, I guess, socioeconomic is definitely a variable, but staying calm and digging into the cases discreetly at the very beginning is probably the most important. And the reason I say that, I worked on the Abdusky case, I worked on a lower court case, and his case went up to SCOTUS under the FDCPA, and he lost. And yet my work in the lower court proves that Wells Fargo was not even in the chain of lien or chain of title. So the McCulley case, U.S. Bank, I've come across them many times, including on my own mortgages. And, basically, I should normally be able to do a typical search into the various databases I've been archiving and find it. But when someone gets it in front of me, suddenly the information disappears. And a lot of this information that the rating agencies used and the databases like Bloomberg and ABS and CoreLogic, they're privately managed. So they're not the same as public records. So it ends up, discretion is probably the first step, and then reconciling what you have and then proceeding discreetly. Otherwise, I have seen information disappear. Is that helpful, I hope?
Yeah, James, it's obviously it's super fascinating to me, and I'm thinking in my mind, like, okay, we have all these credit repair people. How can we translate what you're saying into how credit repair people can forward business to you? Because Stephen, chime in on that.
Yeah, let me chime in. So I think, James, you said something really important that ties it all together. So you cited a court case where you said Wells Fargo was not even the chain of title. Okay. And I mean, I think from the perspective of those of you guys really watching this, credit repair folks, okay, I mean, and by the way, there's a whole lot of work that goes into James figuring all this stuff out. I mean, this is not just, 30 seconds. I mean, this is like hours and days and weeks of work. Okay. But point there being is that if you got a Wells Fargo, hypothetically speaking, right, if Wells Fargo repossession on the credit report, I mean, did Wells Fargo actually have the standing to repossess it and to report that, right? Now, these go more into, borderline actual like legal issues, right? And there's definitely a distinction between credit reporting accuracy versus legal issues. I mean, you're not going to write a letter to Experian and say, "Dear Experian, Wells Fargo is not in the chain of title, and therefore they can't report this." I mean, Experian's going to be like, "Well, I mean, you got to sue Wells Fargo for that," right? That's not like telling that like a data field is wrong or something. But if you've got these items that are reporting, and the furnisher that's reporting them, like if you can argue that person really didn't have the standing to do what they did, which is being reflected in the reporting, then what's being reported is then obviously inaccurate or maybe even false. So let's kind of dive in on that a little bit, James. I mean, so for a first part, like from folks here listening, number one, we've got RESPA, the Real Estate Settlement Procedures Act. Okay, that's a law that enables basically the borrower of a mortgage, either a currently active mortgage or a mortgage that ceased within the last year. So if you sold your house 8 months ago, you can still do it. So either within the last year or a current mortgage, you can send a letter to a mortgage servicer and what's called a qualified written request, and you can request documents from these people, right? So if we've got, let's just going to use your example, that Wells Fargo repossession or foreclosure, we'll say. What are some things that we would want to, now again, the mortgage servicer may very well not give you what you're asking for, but what would be some good things for us to ask for of the mortgage servicer, as like a first step in credit repair, but to kind of lead into, well, hey, should we talk to James? I mean, we may think these people may not even be in a chain of title at all.
Well, I mean, it depends on, unfortunately, a lot of it depends on the financial resources of the party. People I deal with, and I assume people you deal with, they tend to have very limited financial resources. So getting justice and the cost of getting the evidence can be cost prohibitive. What I would encourage is what I'd spoken to Stephen earlier, is when you have one client, and if they're tied into a REMIC trust, go to the SEC files. I can assist in this also, and locate other people in your MSA or your zip code. And, odds are if they're in default, then you can build your client base around a sort of a hub. And if you have 5 clients that are needing legal counsel, in addition to your services, then you have a situation where one attorney may be able to work out something to represent 5 clients. There's always the opportunity if you contact me and I look into a trust and I see something that's irregular, illegal, chain, the chain of title doesn't connect, or I should say the chain of lien doesn't connect. What I can do is draft an affidavit, and you can use it to challenge it. And, I don't know how they're going to receive it, but at the same time,
Right.
that could be a potential, to, I've seen cases where I've worked on where there were settlements and they're sealed. And typically on the rare occasion when the case is settled, it's sealed. You really don't have access to it. The McCulley case I put in the slides was a very unusual case that, and she was diehard. She wasn't going to settle, even though she ended up in prison for a year. So we've got that case, and we've got one of the, I wouldn't call them as well-known a violator of REMIC trust guidelines as Bank of America or especially Wells Fargo, but U.S. Bank is definitely a large player in the U.S. And so,
we had talked the other day, and you had mentioned to me about one of these big banks. There was a case, and essentially it was found that they didn't have the standing to foreclose. And so, so let's try to help our listeners kind of visualize. So you go to the closing agent, the title company or whatever, and you sign the 100 documents, and they notarize that bad boy. And somewhere on there it says, the money is coming from this source, and then you're now going to have this servicer or whatever, and you need to pay these people, 360 payments. Good luck to you. And so that's basically kind of where it starts. So at what point in time does what's on that piece of paper, I know there's an infinite number of scenarios, but just to help our listeners understand, give us a common example of from the time you go and you sign those documents, which clearly state something. What is a common scenario where that chain of lien gets broken to where you have a big giant corporation aggressively foreclosing on you if they get sued properly with the proper research, it's actually found that they didn't have the standing to do that. How does that disjoint happen?
Basically, our regulators and our compliance agencies, as well as our law enforcement agencies, including the more recently founded one, SIGTARP, they're just not following through. The best way I can try to relate to your question is that most courts look at 1 to 3 levels of critical thinking. To find the evidence, you've got to go down the chain of evidence, probably 7 steps to find. If you can visualize a bad guy robbing a house, but he's a known felon, and so he's not going to take the stolen goods to his home, but he does, have a place to stash it. And then every time the police get tipped off, he gets tipped off, and I would quasi say from a political point of view that tipping off. And so he moves it 7 times, but the courts, from a discovery point of view, they don't look beyond 3 times at the most. So you kind of end up with this conundrum where I hear what you're saying, and frequently they bring up flaws in the assignments. Frequently they bring up flaws in the, how it closed. And there's a legal cause of action known as proof of consideration. And I've yet to see a case that really follows the Remick Trust's proof of consideration. And the reason I say that is that I believe there's a very strong possibility that a lot of these Remick trusts, the funds were floated. So in other words, when they transferred them, they didn't necessarily pass through the parties that claimed to be funding them. So basically they were, like a person who would pay let's just say a contractor did some, let's just say, put it in real life terms. Let's say a subcontractor is working for a contractor doing some plumbing work, and he wants to get paid at the end of the job. The client tells the senior party contractor that they're put the check in the mail. Well, the contractor doesn't want to lose his sub, so he mails him out a check immediately, counting on the fact that the check will come in. And so he's technically floating the money. And so when you start analyzing that same concept into Remick Trust, what I've never seen done is the proof of consideration that the banks really did fund and that the trust really funded. So, I mean, it comes to a point where they're selling bond certificates and they're getting their money from selling to the pension funds. But so far as following the proof of consideration between when the consumer signed the mortgage and it made it into the Remick Trust, that's something that just is never really explored. And again, you get into the combination of databases that are privately managed like Bloomberg and CoreLogic and ABS, as well as the third-party providers, especially Wells Fargo, that provides trustee services and produces statements monthly to the bond certificate holders. So getting this information is very, very difficult, especially when courts won't give you the proper discovery. And QWRs, they're good, but only if people tell the truth.
Yeah, so I mean, that all makes a lot of sense. There's a lot of these different legal nuances, okay? But let's kind of bring it back to the thing that we can visualize easiest, okay? You said that there was this court case we were talking, and one of these big bad banks, I mean, they basically lost. It was determined that they had no standing whatsoever to foreclose, okay? Would that be like, a technical issue, kind of like what you're talking here? Or is that like literally they were never actually named anywhere? Somebody done screwed up somewhere and that bank was literally just not named, like it was maybe one of their other entities or something. How does something like that kind of happen?
Well, one of the problems, half the country is judicial and half is non-judicial. So in the non-judicial, you have very few defenses to unless you file your own litigation. What you're describing, it very seldom happens due to the fact that common law, to a certain degree, it's been weaponized against us. And so we're at a point now where a bank attorney can knowingly and willfully forge documents. I've got cases where rubber stamps were used to assign mortgages to other parties, and you can't prove. I mean, if one party is allowed to go into court with forged documents, and as you can see on the slides, it'd probably be a good time to switch over to the slide I sent you.
Please.
The first one is a perfect example. I can tell you a little bit about it.
Okay, let's take a looky here. Let me pull this out of the way.
All right, James, are you pulling that up? Have you ever heard what the settlements are? Has anybody ever told you?
I mean, the McCauley settlement is it was a jury settlement and it was public record. And so she litigated for $1 million in actual damages. It was tied to one mortgage tied to two properties. And the jury was so outraged at what was done to her that they awarded her 5 times her actual damages in punitive. So wow. She ended up with $6 million in that case. But it was. And
James, did they actually pay out on it? Do you know?
I'll tell you what, it's further down the slides, and it'd probably be better for me to give the narrative, but the short answer is yes, they paid out after they lost in the Montana Supreme Court for $6.7 million. And I was telling Stephen the other day, I mean, on a $300,000 mortgage in that range, who can afford to spend $700,000? And that's just the cost of defending. That wasn't the cost of the bank attorneys. So that's part of the conundrum we're in right now, is that we have a lot of bad case law because the evidence wasn't processed thoroughly. And so part of what I'm trying to do, and I can't guarantee this will work, but by bringing in, more parties with more evidence, whether they're witnesses or mass joinders or something of that nature, I'm hoping we'll give the trial court the evidence they need to make rulings where it's more cost effective. Otherwise, like I said, $700,000 to defend a $300,000 dollar mortgage.
And James, how come she ended up in jail for a year?
I tell you, I put it in this further down there. How about I go ahead and focus on this first case, and then I'll get back to it. It's a sad but great example of what we're dealing with right now in our legal system, and with the COVID crisis and the moratoriums being lifted by federal judges. It's highly relevant that we understand what we're up against. So. If we could, would you mind if we focus on what I have titled as the Sedlak notes?
Yeah. So we've got that slide up here. Yeah. Okay.
Basically, this is Minister Wayne Sedlak's case in Minnesota. And he and his wife, Lori Dorman Sedlak, also, he was a minister, and they also operated a foster home. And essentially in 2012, he got to the position where he saved the money, he hired an attorney, and they went through the bankruptcy process, and they saved the foster home. I mean, this man's a minister and a shepherd of his community, and, he's obligated, not just legally, but, morally, and, to do what's right. And I was brought in on the 2014 case. And as you look at these two notes, these were filed under perjury of law into the court system. I mean, just look at, this is an example of just how sloppy the forgeries are. Same court system, two different court cases. One was filed by a bank, the other was filed by a Remick Trust. And so when it comes down to it, basically they went through the whole system, and yet the bad guys, to the best of my knowledge, were never punished. And so you see those two mortgage notes when forgery and counterfeiting becomes legal. And I know for a fact that Minister Sedlak, because I went with him, went to law enforcement. We reported it on a criminal side. We participated in the civil side. And due to the blatant, obvious fact that these were forgeries, to make it admissible, we even retained, or Minister Sedlak retained, at this point in 2014, he was forced to go pro se. He had already, spent his budget saving the foster home in the first case. So essentially, we even made it admissible evidence into the court that it was forgeries. And yet, some of the questions you're asking me is, how do we win? But I also want you to see, this is a problem. Even when we have the prima facie evidence, cases don't win. And so
you've got here. So you've got a 2012. So everybody can just kind of understand what we're looking at. Because you're saying forgery. One of them is titled a 2012 Pacer document, and the other one 2014. There's no signatures on here. The only difference I really see, one of them has the word original stamped on it twice. And there's like a big black bar here between adjustable rate note, and the other one, the header looks a little bit different. So, but are you saying but they're dated the same, December 22nd of 2006. So you're saying one of these, these are two separate documents very clearly, because there is a space here on this one.
Well, when you're dealing with your courts, frequently you're going to have to provide, proof that you're entitled to foreclose. So, it's one thing when you come in with the endorsed mortgage note that's, that says you're entitled. But it's a whole nother situation when you walk in the door with a counterfeit document and you're foreclosing on somebody.
Okay, so kind of from what we see here, though, they look pretty much identical in wording just from the screen clip. But what you're saying, obviously, these are big, giant documents, and so somewhere in these documents, there's stuff that's. So the 2014 one is the one that you're saying was the forged one.
Well, to be honest, they only presented. I know when I recall when I helped them draft the discovery, that I requested that they bring both originals. I mean, legally speaking, they're required to file the original. And so, here we've got, what I would basically, until they prove otherwise, state that they're both counterfeits. They only brought one of them for the document examiner, and the judge at that particular day, this would have been back in 2015, he literally held the courthouse open, I think, until like 7 or 7:30, so we could finish depositions and the document examiner could finish. But ultimately, the bad guy wins. I mean, I hate to say it, but this is how low the threshold has gone, that if a bank attorney comes in and attests that this is a legitimate document, I mean, case law has gotten so difficult that as long as they attest to it, they get away with it in many cases.
Cool. So this next slide, you got the Arapahoe County, Colorado. You got this guy holding, it says counterfeit note, and then you've got a pro scope for $150. So what is this pro scope that we're looking at?
It's basically a device you can slide onto like an iPad or a iPhone, and it magnifies. It's referred to sort of as a microscope, but it blows it up. And what you see is a document examiner, Gary Michaels, and this was a case in Arapahoe County around 2014, I believe. And essentially, we're in the courtroom doing a document examination, and when he blew up the signature line, you can see the black line that the client signed on.
Mm. Okay, now, so that's the signature line right there. So this thing is huge.
Do you see what's wrong with that?
Well, help me out with that one. Oh, the line is on top of the blue ink.
Yeah, this is one of those scenarios where if I treated you as the judge, I'll make Your Honor, we've got a fraudulent document in your court. Will you please sanction these people? Yeah. And if he doesn't recognize it, and most people don't, I would say, Your Honor, how did my client sign underneath the form? Yeah.
Okay. So this is the black line here, and then this blue is the ink, and clearly, it's like those images of landing on the moon, where it's kind of like you got like the little scope in the picture, and that's like behind. Never mind. All right. So back to this.
But again, this is an admissible situation where the document examiner examined it, submitted to the court. We're told it was going to go to the DA, and no prosecution happened. So
let's talk about this real quick. I mean, so again, kind of dial it back to our audience here. I mean, so if we're able to send even qualified written requests, and ask, this is a perfect reason why it's important to ask for original account records. Like, I mean, forget about all the other chain of title and all the other stuff, which they're going to tell you to go pound sand. They're never going to give that, to us, right? As we just send credit repair letters. But with a qualified written request, you certainly should be able to get your original records. Now, it may be really hard to tell this because you're probably going to get black and white copies. But still, if things are forged, I mean, this goes to show you that if you can get those original records, you look and see if things seem to be out of line. Is that a reasonable assessment of kind of first steps for credit repair persons?
I would call it sort of a legal bullet. Like, if you want to win a war, you want as many bullets as you can find. And this is just one of them. And for the most part, forged documents, they're unfortunately just swept under. Yeah. They just, but if you walk in with 5 people and they have similar scenarios, and if you expand the damages, like if you file for a whistleblower award and show that they're operating 2 different account numbers, and that this Remick Trust is not only evading taxes, but they're profiting from, say, insurance payments for default insurance. Well, suddenly, you're proving unjust enrichment, and hopefully the threshold by a judge who will go critical thinking, say, to level 4, suddenly he's going to be forcing them to answer the QWR and answer the discovery. So we've kind of got a threshold where we're not getting the bridge, over to critical thinking 4, 5, 7, up to 15, so we can understand, why, our system has been turned upside down after the 1986 Tax Reform Act.
Okay, so we've got the basically, I guess, the judgment here, or the Montana 18th Judicial District Court, Gallatin County. So we've got the $5 million award here. All right, so that's a big
that's punitive. She got actual damages of $1 million and punitive damages of the $5 million. So remember, punitive's sort of there as incentive to teach banks a lesson that you can't do this.
Okay, and then we've got this this picture. Mary McCauley, a threat. We've got see Bill Clinton over here. What are we looking at here?
Well, essentially, she was. I would describe her as she was a professional photographer, a bit of a diva. I would, I've never met her in person. I've only interacted with her by phone and email. But she passed a security clearance to be a photographer for Bill Clinton, one of his fundraisers, and here she was, with Steven Tyler. Neither one of those men looked threatened. And the reason I say I point this out is when you go to the next slide. 10 days after she won the state jury award, a federal court judge basically put her in prison claiming she had impersonated a federal agent. And all she did was she asked for law enforcement help, but she didn't get it. So she tried to get the documents that she was entitled to from the title company. And she made sort of a sarcastic remark. And there's a slang that women will call men dicks. And so she basically spelled it out. She's like, I'm with DICS. I want a copy of these documents. And the next slide will be her Twitter when she got her to prison. And so I think it's best to read her own words. I think you went, maybe I've got them out. Oh, no, I'm sorry. That's my declaration to try to get her out of prison. It'd be
she kind of went to the title company basically and was like, hey, I'm with DICS, some sort of agency. Is that even really an agency acronym? Or
no. She was being totally sarcastic.
Okay, so she was
telling the two guys that scammed her that that they're dicks. She's just spelling it out. I mean, these are not the smartest.
Okay, so she went in there. She's like, I'm with DICS, and I need these documents. And they were like, okay, we're going to give you these documents. And then she
no. They didn't. But it's one of these situations. What do you do when you've been violated and you go to law enforcement and they don't put the bad guys in jail?
So she lost. So she won the lawsuit, and then so then 10 days after that, is somebody prosecuted her for impersonating the law enforcement, even though there was no such agency. So but obviously it would have to be some sort of a government agency that prosecutes her. So are you kind of suggesting that the bank was in cahoots with law enforcement and they wanted to just?
I'm only going to state what's on the public record, and you can see, with my declaration to get for her release from prison. There was a U.S. versus McCulley. First there was McCulley versus U.S. Bank. Then next there was the U.S. versus McCulley. And this is her statement when she got her to prison. So these are her words. And so I don't know if you want to read it into the system, but it's well worth reading.
So obviously she kind of. So somebody put the screws to her. I mean, it kind of sounds like. So she won the case, and then they were like, "Oh well, but there's more. We're gonna prosecute you."
I guess I should, just elaborate a little bit. It probably took me a month or so before I could even communicate with her in prison. I mean, she was sort of dieseled around the country, and then ended up in a very bad prison, Hazelden, West Virginia. Over the course of the year she was there, she was offered settlements, but the bank appealed the case to the Montana Supreme Court. Spent her lawyers spent $700,000 defending it, and ultimately, from a financial point of view, she was awarded the $6.7 million. And so, but that's kind of like I mentioned before. How do we, get the case law working, in alignment with our constitutions and like a lot of our written law? Because remember, under common law, your regulations can say one thing, but, if case law changes those rules, and it can't do that. And that's a lot of what I see we're up against, is that the threshold for forged documents. It just, you can walk in with a forged document as an attorney for a bank and you don't go to jail. Now, if we can, we can prove damages and unjust enrichment, well, possibly we'll have, bank attorneys not willing to walk in with forged documents any longer. Right now, there's no downside. And I hate to be, but it's a fact. I've seen it.
So let's talk about that real quick, and then we'll get to this next slide, this Bloomberg slide. But that's okay. I think that's a really good point that you raised. Okay. I mean, I think we can all agree here. There's no doubt that there's a massive amount of forged mortgage documents for foreclosed homes, right? So what basically I just heard you say was that the lawyer for the big bad mortgage company, the big bad bank, will walk into court and have this big old stack of documents, some of which are forged. There's probably no doubt that they're forged. But at the end of the day, the judge will be like, well, what you want me to do? Just go ahead and forgive the debt and give them a free home? I mean, they lived in a home. So if I'm hearing you correctly, basically it's kind of like just turning a blind eye to the fact that these literally were forged documents and technicalities. But the judge will say, well, they clearly lived in the house and paid for it for a while. So, these documents may be forged, but that's a whole different thing. Nobody's trying to prosecute these people for signing forged documents. The person here is your client, who's the consumer who didn't pay, right? So is that kind of what I heard, was that there's just really...
And again, that's when you're, using critical thinking 1 to 3. When you get up to 4, 5, 6, you realize that these remit trusts are involved in tax evasion. They've created, again, an unfair advantage, for, banks that pay their taxes, which I'm speculating upwards of 5,000 banks pay their income taxes on the interest income that, that their borrowers, have taken out on their homes. And then you've got less than 100 banks that probably control 70% or more of all the mortgages in the country, and they're evading their taxes. I mean, there's a good chance most of our, maybe all of our national debt would be retired if the law was enforced. And I'm citing 26 USC 868 through G, which is the guideline for setting up the remit trust. But unfortunately, when you only look at 1 to 3 pieces of critical evidence and you don't follow the information, we end up in these horrible conundrums that we're in right now. And so, and this is what I'm describing as post 2008. And now we have a more legitimate, financial catastrophe, which is the COVID situation. So unlike 2008, where there's evidence we can prove it was manipulated, COVID, that's more of an act of God. So we're gonna have I don't know what's going to happen, but I don't feel good considering forged documents are going through the system. And like you described before, these rating agencies were putting, AAA on anything. And the reason I put these next 2 slides in there is that I want you to understand that even if honest stockbrokers who are investing for pension funds and annuities and other investors, even if they didn't trust the ratings of the rating agencies, I complained repeatedly to Bloomberg Terminal and I had a contract with them. And I said, your documentation is not adding up when I reconcile multiple databases, including the SEC. And the 2 screenshots you're getting ready to see is a perfect example of how data was being manipulated so you couldn't even pull the information up. So in other words, if you were trying to do due diligence as a stockbroker for a pension fund and you went to check the payment history to make sure that if you buy a bond certificate on this tranche, that you're dealing with credible financial data, you wouldn't be able to pull it up unless you knew how to dig into it. And so, if you can, do you see what it says on that slide?
Well, let's back up for just a quick second for our listeners. So Bloomberg is the company that has the software here, basically this big database. And so, what happens is Bloomberg has databases of things related to securities and stocks, as James was saying. And so these trusts that have all these big giant pools of mortgages in them, you should be able to go, right, James, into Bloomberg and see the actual mortgages that are backing the trust. Is that kind of what you're trying to say we're looking at here on a high level?
I would use the term drilling. We call it drilling down. And so you would go in, you would locate the trust or this particular command function that they disabled after I brought this to their attention. And I shouldn't say after I brought it to I complained for months that their system, wasn't working. And my New York account reps were a little bit arrogant, like, who are you? They really didn't take me serious. And then I finally got this case that proved I was right. And so essentially Bloomberg, ABS, CoreLogic, there are others. But my big point is that you cannot run due diligence if the private databases are not providing the information, and yet we're paying for them to do it. and I was paying $2,000 a month for this service. So I mean, I was a subscriber. I wasn't logging in free or bootleg. So I can't justify.
Yeah, so we've got your second slide here. This one shows, okay, clearly it's a foreclosure. Okay, now is this a different record than you were trying to search for the first one?
If you go up to the first one, you'll see that the zip code and the loan amount, and this is one of what will make a case easier to follow data is when you have an unusual loan amount. So when you look at that loan amount, it isn't an average loan amount, and it's not 300,000.
157.10, yeah.
Yeah. So basically, when you look at those in there, look at the components there with the zip code, and then you go down here, this basically I use the loan number, and usually the loan numbers are switched. And so in this particular case, occasionally, like 1% of the time I would find, or not much more than that, the loan number happened to come up on the search. So here the parameters are there. And on the previous one, it says there's no file.
Okay, so what we're looking at here is a record of a loan that's in foreclosure status. Is this loan but what are we searching here? Is this a loan that's in a trust?
From a spreadsheet point of view, what I was searching was the loan amount, the year it was closed, and the zip code. So the previous one showed that there was no files. But when I searched it by the loan number, I was able to locate it. And as I mentioned, frequently when you're dealing with these REMIC trusts, you might close on one loan number, but they're reporting it to their investors and bond certificate holders under a different number. So literally,
so that's kind of my question though. So is this mortgage right here in a trust essentially?
Yeah, absolutely. Absolutely.
Is that kind of like with this WFHET 2004-2? Is this kind of like this?
That's a history. The trust on that one, you see the issuer, CWL, that's Countrywide Loans. And then it's 2006, and then I guess it's 1-3.
Okay, I don't see the CWL on here, but okay.
You just second column.
Oh, there we go. Okay, cool. Yeah.
So what happens when you're in the SEC files, you'll see these long names, but at the same time, once you get into the databases like Bloomberg, they reassign codings. And so CWL is one of multiple codings for country. On that one, you see the issuer,
okay, yeah.
CWL, that's Countrywide.
So the series, the 2006-13, so that's kind of the series of bonds or whatever.
Like
We've got a little bit of feedback coming in.
CWL is one of multiple codings for country.
Let's see. There's some feedback coming in here. I don't know if you guys want to maybe quick mute and unmute. Okay, I just muted you, Doug. Let's see here. It's unmute. Okay, let's see if that works better. All right, so basically what this is showing is this series. Okay, so the series, that's basically like the bond series from the trust, essentially. So there's a bond. There's a bond that some poor schmuck purchased out of this potentially AAA rated trust, where the assets backing it, this particular piece of that asset was a foreclosure, right? I mean, that's kind of what we're looking at here, right?
well, we're kind of skipping a step. The first step is, why are they hiding this particular, mortgage from? See, this was in litigation, and this particular client was given some media exposure, similar to McCauley and similar to Obdusky. But fortunately, I was able to get into this case before things started deleting. And in this particular scenario, I mean, you understand how simple it is for a spreadsheet, because all that is really a spreadsheet.
Yeah, totally. So, but that's so that's kind of what we're looking at there. I mean, so that makes sense. So you've got the ability to search. So for the listeners here, so we've got bonds that were being sold from trusts that were backed by mortgages, and there you can clearly see that mortgage was defaulted, right? So they were definitely not AAA rated bonds that these poor people were buying. And then to James's point, the database, the Bloomberg database, he sees that there's evidence of them kind of, tampering with the searches and stuff so you can't really easily find the really nice stuff. And I know, you've mentioned it before, you've seen them delete records. I know that's not really part of this one, but there's
let me Steve, let me really correct. I was, there was a fictional movie called 99 Homes where they reference a clerk of court messing with internal files. I've seen, including on the McCulley case, information disappear out of the court files. PACER, for the most part, is secure on the federal level, but on county levels, I've seen multiple cases where documents are taken out of the courthouse, and so I hate to be negative, but I also want to be honest, and so. But jumping forward, I guess we can close on time. This was the first case I technically worked on. And I both had standing as a victim, and I want to be really, really honest that the reason this case went forward, I believe, I reported this particular bank. It was FRM out of New Hampshire, and this was around probably 2008. And essentially, they were a smaller bank. They weren't a larger bank, but they were sort of doing a copycat with trust on a state level instead of on the federal level of the SEC. And ultimately, I got tipped off that the bank president fled the country. And so I sent the information I had to WMUR TV station, and they picked the ball up. And essentially, because the media got in front of it, we were able to get the guy prosecuted. But even in the end, I actually had to fly in at my own expense and oppose the U.S. attorney. He was pulling plea bargains. Like that, they were going to let him go to prison for 10 years, and there was 2 suicides in that case. And after 4 or 5 of us testified, the judge threw out the plea bargain and put the bank president that day in jail for 15 years. So,
suicides or witnesses got suicided. Were they real suicides or murders that were like, oh, poor guy, he suicided himself?
Well, I mean, there's I know from my knowledge, I think it's gone both ways, needless to say, but I guess I'm just trying to be accurate in what I'm showing you. And so, the FRM case to me, and this is when I started butting heads with the AG that was running the national mortgage settlement. He wasn't processing the facts and evidence, and I've taken literally, I would estimate around 50 million in losses, trying to, from my real estate investing business, trying to bring facts and evidence forward. And so I have qualified in state and federal courts, and I have, it's very interesting, the scenario when we pay our taxes and we have law enforcement and compliance agencies. And I've even started training a CTARP agent once, and somehow it just, they basically, I guess, an upper level, whether it's political or potentially, a higher up in the chain, repeatedly investigations get shut down. I've got communications that really sound cryptic, telling me not to lose hope, and yet a week earlier, I was teaching them on how to drill down into these databases. And so this is,
you got those.
I want to provide evidence, but I want to provide it on a larger scale. So, you're not, he said, she said. You've got, 5 victims sitting there with, evidence that proves that they're telling the truth.
Yeah, you get those cryptic voicemails from the bank presidents that say, James, look over your shoulder when you go to sleep tonight, right? We're watching you. But we can still, let's go a few minutes over here. I mean, there's not like necessarily need the hard stop here. Let's go another 5 or 10 minutes if we could. So we've got Warren Maxwell says awesome, and Rachel Kite was the one earlier. She posted that she actually lived in St. Thomas. But so Doug, man, why don't you chime in here? Let's kind of take this thing to the runway, but let's talk a little bit about, because you're the damages expert, man. Let's talk about all this big giant freaking smorgasbord of fraud and deception and deleting evidence. And my goodness, man, where do you even start, Doug? Where's your head at this?
Yeah, there's, James, a lot of great information. And so as far as, quantifying damages in something like this, I think the closest thing I can sort of equate it to in cases that I work on, it's typically where there's been a wrongful foreclosure that's happened. And obviously it's been reported to the credit agencies and someone's credit's been harmed. And so I'm sort of curious, James, the cases, the way they come to me are sometimes sort of in a form of a question, meaning, is this even possible, first and foremost, to quantify damages? And then the other part of it is, we have this wrongful foreclosure. we've had to file BK because of this or that. So in these cases, are you dealing at all directly with the plaintiff, or are you just, I'm wondering, how do these cases come to you? Who's hiring you, and then how are you getting paid on them?
Well, I mean, one part to remember is that as all of this unfolded, CFPB was formed as well as SIGTARP. So CFPB, as well as many states, passed laws that you cannot collect payment up front. So, you know, getting paid is difficult. I'll be the first to say it. And then you have clients who can't afford to pay you. So I'm caught up pretty deep. You know, as I said, my losses are substantial. And so I tend to not charge anyone up front. And I usually ask 30 days to research. And then if I find what I think can be useful evidence, then I take it to the, you know, to the client, which frequently is pro se. And, you know, sadly, when you're pro se, you lack the sophistication of just simple court procedures. And a lot of times bank attorneys will just smoke you on those simple procedures. So that's why, you know, I'm also hoping that by bringing, you know, by identifying a tax ID number to a REMIC trust, which will involve multiple financial parties, and bringing in multiple victims, that we can potentially go forward. And equally important, you know, it coming up with a calculation that's credible to prove damages. You know, and that's, you know, I can't begin to say how invaluable it is to be able to prove damages. Because we're kind of talking, you know, various aspects of litigation as well as reporting crimes. And so what you're doing, if you can, I seem to recall in the legal field, if you had an auto accident, attorneys would in general tell me it'd be like 3 times your medical expenses would be the settlement if you weren't critically injured. But of course, if you're a surgeon and you lost your hands, you know, it's going to be a lot more than that. So, you know, coming up with something that will make it, you know, you can process it faster, if that makes sense.
Sort of coming up with a metrics or a methodology that's court accepted and it's understandable.
Right. And once we get, you know, case law to that effect, you know, say if you, I guess one of my ideal approaches to a equitable resolution, or a step to a quasi-equitable resolution, would be to use our central accounting system, which is basically the Internal Revenue Service. If we can prove, you know, something was illegal, that the homeowner, if they had a $500,000 home that was illegally taken, and that the IRS would give them a $750 credit to buy a new home, but they would also require that the current homeowner update his deed. And I'm not sure if you've noticed this or not, but one of the patterns I see constantly is that one property owner might have a warranty deed, title insurance, everything's credible, but when they go and they sell these foreclosures, they'll set up a lesser deed, like a limited warranty deed, which is kind of like buying a used car. You know, if they did something wrong, they're not liable. So, I mean, a big part of the problem we have with our land records right now is a lot of the properties, you know, are not really insurable, because there's a critical flaw in the chain of title and the chain of lien evidence, due to the simple fact that we didn't go, you know, 7 levels of evidence and critical thinking. We stay between 1 and 3. So a lot of people can prove that they have damages, but we've got to process the evidence further. And then we've also got to, you know, how do we clean up our land records? And what's an equitable solution? You know, a person who lost their family home, you know, they might not care that they're getting a $750 credit as an incentive to go buy another home, you know, with like a $250,000 bonus. You know, they may only want their home back. And so then you've got a serious court case if you can prove that the other party has a limited warranty deed and they got it conveyed through fraud.
Wow. Yeah. I mean, it's a lot to think about as far as where the damages are occurring, and how to put a methodology to it that's going to be acceptable. Obviously, more than I can just come up with off the cuff right here today. I wish I had a better answer for you, but definitely would want to take some thought on it. But I also see, let's say from my side of it, and I also think from the credit repair side of it, I think that there's ways that we can either help you in finding these people, right? Or at least I think on the credit repair side, credit repair organizations are going to come across these people who have these types of problems. But then, James, you're sort of put in a position to sort of piece everybody together and try to make a case out of it where you can get some representation instead of going pro se.
Yeah, I guess I see it kind of flip. You get one client that has the mortgage is tied to a REMIC trust, and then going to the SEC files, being discreet, locating other parties, verifying, and then trying to go forward where the parties can potentially share the same law firm, whether it's 5 individual cases versus just a one-off case. And I'm not denying our legal system should function better, but the one-off cases, they tend, especially pro se's, they tend to lose even on simple administrative situations. And it's just like I said, you read the McCauley Twitter, and you just got to ask yourself how in the I mean, even myself with my credentials, I never saw this coming until I was, literally caught in the crosshairs. And I wasn't in financial trouble. My company was cash flowing, and I mean, I had, I think, 8 or 10 million net worth, and yet I just got froze out. And so I just, it's there's a lot more I can, point out, but it just, we're getting to the point where we've just got to face that we have an organized crime network of less than 100 financial institutions, mostly, big bank and Wall Street, and we've got to go and prosecute them. And one of the things I like about my CV is what I did when I opposed the U.S. attorney in the FRM case with Bank President Scott Farah. It proves that, a small bank president can go to prison. And why can't a large one?
Too big to fail. One of the takeaways, I think, for everybody watching this is that there are multiple victims of this. I don't know if we call it a crime. I mean, but whatever the hell we're going to call it, because clearly the consumer, I mean, if there's all sorts of fraud and shenanigans, okay, the consumer is evidently some sort of a victim. But then with that Bloomberg screenshot where, whoever is the poor schmuck that bought those bonds thinking that they were getting a AAA rated bond. And right there, you got the big old foreclosed, for that particular mortgage that was backing the bond, and then these big banks, they're just packaging it all up, getting them rated as AAA, putting them in these, so they're getting paid both ways, which is a whole other conversation. I mean, who even knows how the hell that's legal, right? Because they're getting paid when they lend you the money to buy the house, and they're getting paid when they sell the bonds, which are backed by the same mortgage, the same home.
Well, keep
double dipping the meat, but go ahead.
Well, keep in mind, when they're operating different accounts, when they're reporting, a different set of records, and bankruptcy court is one of the best places for records because you'll have the motions to lift stay that have a separate set of accounting typically. You'll have the, POCs, the proof of claims. So one of the best places to get accounting you can get certified are the bankruptcy courts. But when you start talking about multiple, I've seen patterns of 7 incomes, and I would say you're allowed the 1 income plus your overhead, and that's the interest income. But once you dig into these SEC filings, you realize that there's default insurance. And so there's various, aspects of other income, and it quickly draws the cause of action known as unjust enrichment. And I know for a fact, and this is one of the advantages of if I can get in deep enough before you get into the discovery phase and before you're getting jerked around, and I hate to be rude like that, but that's what it comes down to. If we can go to the, if you can file discovery and the bank comes back and they'll say it's too broad or irrelevant and they won't respond to the discovery to QWR, I draft an affidavit and say, well, this is information I have. These are the parties I interviewed. And to be very clear, and I'm going to cite the U.S. versus DSI or the Ninth Circuit, I've gone 2 to 3 levels deeper than them, and I've done it probably 50 to 70% of the time. So even though our prosecutors have claimed finding these bond certificate holders is impossible, I've been able to some cases, drill down to the broker who made the trade. And if we're subpoenaed the broker and you're providing the evidence that, he utilized for due diligence on Bloomberg, and he utilized from the SEC, and he utilized from the monthly statements from the bond certificate, manager that's sending out the reports, so they call it reading the tapes. Suddenly you have all this conflicting information. He's in a position to be sued by the Teachers Association or, the Firemen's Association, whoever's pension fund they're managing. Then you're getting all the guilty rats on the same, ship, and we can hopefully prosecute them. But it's a lot of work, but I'm telling you with firsthand knowledge on a number of cases I've gotten that deep, but getting it all together, it's going to take some kahunas. I mean, Bruce Jacobs, if you were following his bar sanction hearing in Florida, he's a former prosecutor, and it's unbelievable the pro bono work he's done. And he's being chased around. Mark Stopa was a shockingly winning attorney, I think around 7,000 cases, and he was only winning dismissals. He wasn't winning lawsuits in Florida, and yet he got disbarred. And I mean, we're really, I don't mean to sound like it's a conspiracy, but the favoritism towards big corporations and their attorneys, I mean, it's very biased.
Definitely not a conspiracy. It's a well thought out criminal organization enterprise, right? But let's kind of back up for a quick second here, because there's really two victims, right, as you were mentioning. And so the problem that we see as credit repair folks, if we've got a foreclosure on the credit report, I mean, our consumer, if he had a foreclosure, it's like, okay, whatever. I mean, you got the house. Good luck getting a judge giving you a free home or restitution. But the real victim is the bond holder, like you were saying, right? Because they're the ones who bought that AAA rated bond that was rated AAA, but then is chock full of all of these, the assets backing it, which are foreclosures. And so the real win is if you can find the bondholders that are wanting to sue the trust and whatever those big banks offer, fraudulently putting together this package. And then also if you can find the people who had the repossessed foreclosed mortgage in that trust. You got to tie them together.
Well, I mean, actually, this is one of the very unfair ironies, and this is where standing comes in, and I've heard you bring it up before. When investors sue, they have a high probability of settling or winning. All right, it's the homeowners and the property owners that don't have standing, and so they're the ones that tend to be left out. But I agree 100%. When you look at the Census Bureau and you look at the retirement boom and the way this is all played out, in the 1986 Tax Reform Act, then the formation of MERS a few years later, I mean, the timing is perfect that, we went from a traditional bank lending system, where the bank recorded in the county records, and every time they sold the mortgage, the county, received recording fees, and they didn't dare not have their name recorded, because they wanted to be in the chain of title, or what's often referred to as first in time, first in line. Then all of a sudden, the MERS database was set up, which made it, in many cases, impossible for a property owner to go to the county land records and see who really owns his mortgage. And then it's sold repeatedly within this, I call them kind of like a Sam's Club or a Costco, because these MERS members decided that they could just sell it amongst themselves. And so, there's the fees that are being denied to the county. And at the same time, when you look at the bond certificate holders, the trust, they basically are to the benefit of the bond certificate holder, just like banks are to the benefit of the stockholder. And so, when you have a bank going into court, and they did this frequently around 2008, 2010 to 12 even, where the banks would go in and file fake POCs. And this is the way I got pulled into this, is that I met a woman by the name of Elizabeth Jacobson. And she was involved with a $174 million fine against her former employer, Wells Fargo. And when I met her, and we've spoken about CFLA before, and she did a seminar for them, for Andrew Lehman. And when I met her, she's a former banker, and she's telling me our mortgages are showing up in the stock market, in the SEC record. And yet when you go into the public filings and the court records, you've got Wells Fargo claiming they own something. And then when you start following the chain, it can't be in two places at one time. And so that's really the conundrum. So if you close one mortgage on one property and magically two different parties own it, and that's impossible. It's against physics. And yet that's exactly what has happened in a number of cases. And proving the ones we can get the evidence on is really important to being able to have some correction with our land, with our land records and our justice system.
Well, this has been exciting. We're probably going to have to do us a follow-up on this one. But so, James, if anybody wants to get in touch with you, man, what is the best way for them to reach out to you?
Just send me an email. I prefer to deal by email. That way I can go back and see my notes. People try to call me, but I typically just prefer to have email. And And like I
What's
said,
the
I
email?
don't charge up front due to Regulation O, and so I'm happy to look at files and tell you what I can find.
Cool. What's that email address?
It's the number 1. I'll just type it into the.
Oh, this thing won't. It won't post to
It won't.
Facebook, I think. Yeah. Unless you
Okay.
put it in.
Okay. It's the number 1. The letter S is in Sam, T is in Tom, C is in Cat, A is in Apple, P is in Paul, at msn.com.
One ST cap, first cap at msn.com, right?
It was my old banking email, First Investors Capital. So when I worked for a net branch, which I imagine Mr. Miner might remember when we were back in the 90s, there were net branches. Yeah.
Yeah.
I worked with American Investment Mortgage in net branch and John Lewis.
Cool. So first cap at msn.com. And then Doug, of course, you just like talking to everybody and anybody, people who want to be experts, people who aren't experts, everybody in between. How do they get in touch with you, my friend?
Yeah, easy. Doug at dougminer.com.
Dude,
But that's it, just Google my name. But either way, happy to talk to him, email or on the phone.
Big baller like Doug Miner. He just has to tell you guys, listen, just Google his name, man. He's just that famous. James, one day you'll be like Doug Miner category. You'll just be able to say, just Google my name, man, So, and then of course, if you guys like this, obviously, we've got a credit repair training course, $99 a month, over 100 hours of content, more information than you probably could ever digest. You can go to creditrepairtrainingcourse.com, sign up for the free trial, take a look at it. Again, James, I appreciate you, sir. We will definitely have you back here. And Doug, always a pleasure doing this with you. And for those of you guys watching us, it's time to sign off, but we will see you back here on the next episode.
Stephen, one quick suggestion. Send me a few names. I'll look at the trust, and then maybe we could have a more detailed conversation next time, looking at actual data.
Cool. And if you guys have anything on credit reports, foreclosures that are kind of nasty looking, get them to me. Get them to James, and we will figure that out. So we will see you guys on the next episode.
Thanks, guys.